Good morning. I'm Dan DeRose with 19 News Now, coming to you from our digital desk. We're going to be taking you into court for the sentencing of a man who's been found guilty of attacking a Norton police officer. We're talking about Keith Parton. He is going to be sentenced today. The officer that he attacked was simply sitting in a parking lot in Norton when he was attacked by that man you see there on the screen in the lower right. That is Keith Parton. He has been found guilty of felony assault on an officer, and today is sentencing day. Let's take you live into the Summit County Court of Common Pleas.
From the Summit County Jail, present on his behalf in person is counsel Attorney Joe Perry, present on behalf of the state of Ohio, Attorney Charles Roman. We're here for a sentencing hearing.
All right, and the parties are ready to proceed for sentencing?
That's correct, Your Honor.
We are, yes.
Mr. Perry. Okay. Mr. Parton, that is you, correct?
Yeah.
And you are able to hear and see these proceedings, correct?
Yeah.
You do have a right to appear in person, but you are appearing by video today. Do you consent to appearing by video?
No, I'd like to appear in court.
In person? Yes?
Yes.
Okay. However, you're able to hear us, right? You're able to see everything?
No.
Okay, what are you missing?
I don't know who all these people are over here. I don't know what's going on. I have no idea what the deal is here.
Okay. Are you able to see the courtroom?
Yeah.
Okay.
I see you here.
All right. I'm going to make a finding that the technology that is provided to us is able to ensure the rights and privileges of all of the parties. And over your objection, Mr. Parton, you will appear by video today for purposes of sentencing. All right. I want to hear first from the state.
Thank you, Your Honor. The victim in this case, Officer Jonathan Travis, is present. It's my understanding that he wishes to make a statement, so I'd ask at this time he be permitted to do that.
Of course. Officer Travis, please come forward. If you can stay at the podium, ensure that microphone is on. It should have a blue light.
Yes.
Okay. All right. And for the record, if you can just state your name, spell your last name, and then whenever you're ready, go ahead.
Jonathan Travis, Travis. Your Honor, I want to thank you for the opportunity to speak today. I also want to thank my family, the communities of both Norton and Barberton, the Norton Police Department, the Norton Fire Department, the Barberton Police Department, and the Barberton Fire Department for their support throughout this ordeal. On May 28, 2023, I went to work as a police officer for the Norton Police Department, expecting to return home safe at the end of my shift. As we all know, that did not happen. My life has changed since being assaulted by Keith Parton. I still cannot remember anything from the incident. I have a series of doctor's appointments I must attend. I get headaches, forget the names of things, cannot multitask, and struggle to remain focused to complete important assignments. These were all simple things I could do on a daily basis, but not now because of Keith Parton's actions. I loved going to work as a police officer and will not return until it's safe for me to do so. I do not want to make a mistake that could jeopardize the lives of my fellow officers or the community members. Your Honor, I ask that you provide justice in this case. Do not give Keith Parton the opportunity to harm anyone else. Some of us may never get the chance to give an individual what they want. Your Honor, today you have the ability to give Keith Parton what he wanted. Please grant Keith Parton his wish and send him to jail for a long period of time. Thank you.
Thank you, Officer Travis. Prosecutor Roman.
Charles Roman on behalf of the state. Your Honor, first and foremost, I would just like to bring to the court's attention that the Ohio Revised Code demands that this case result in a prison sentence, so community control is not an option. The court may select an amount of time from the F1 range, and that is what Mr. Parton will be serving. He will not be subject to judicial release. Furthermore, I'd like to remind the court that the state did file a sentencing memorandum in this matter that lays out Mr. Parton's history and certain details of his history. So I won't rehash the entire motion, but I do want to raise some points that are certainly relevant here. The Ohio Revised Code demands that we consider the need for incapacitation, deterrence, rehabilitation, and that we protect the victim and the public from future crimes from not only the defendant, but from others. There are certain factors that the court must look to when considering an appropriate sentence for a defendant. One of those factors is whether or not the victim suffered serious physical, psychological, and economic harm. And as we heard from Officer Travis during the trial, as well as in the courtroom here today, he has suffered serious physical, psychological harm in that he no longer can be a police officer. He's suffering from cognitive issues. He does not feel comfortable returning to work. And in so, one can make the conclusion that he's suffering economic harm because he was an officer not only at Norton Police Department, but also Barberton Police Department. So all of those factors are present here. Some factors for the court to consider that makes the offender's conduct less serious are that the victim induced or facilitated the offense, that the offender acted under strong provocation, that the offender did not cause or expect physical harm to persons, or there were substantial grounds to mitigate the offender's conduct, even if they don't constitute a defense. Your Honor, you sat through the trial. None of these factors are present. Jonathan Travis was sitting in his car, talking on the phone to his brother. He pulled over as to not be talking on the phone and driving at the same time. He in no way induced or facilitated this offense. Mr. Parton did not act under any provocation at all. This was a random act of violence. The offender did expect to cause physical harm to Jonathan Travis. That was his stated goal. There are no grounds to mitigate his conduct. As laid out in the state's sentencing memorandum, Keith Parton has an extensive criminal history dating back to 1995 when he received his first assault charge. Since then, he's received numerous crimes of violence, convictions, charges, prison times. He's run the gamut of court sanctions, anywhere from scram bracelets, monitoring his alcohol intake, up to community control, through local jail. He's done several prison stints. And here we are, once again. He has a history of criminal convictions. He has not responded favorably to any sanctions imposed by the courts. He shows a pattern of alcohol-related or offenses related to alcohol and doesn't acknowledge or refuses treatment. We heard him on the morning of trial declare that on the day of this incident, the last time he consumed alcohol, and he consumes alcohol to self-medicate for pain in his leg. Well, as history shows, his criminal history, and from what we learned from this trial, these are the things that happen when Mr. Parton uses alcohol, and he hasn't given us any reason to believe he's going to stop.
Proper medication from a hospital would help.
All right, Mr. Parton, you'll have an opportunity to be heard. Please let them finish.
There's factors for the court to consider. That his recidivism is less likely. Again, none of those are present. One of them is that he has no prior adult convictions. As stated, he has numerous prior adult convictions. That he's led a law-abiding life for a significant number of years. He hasn't. He has an extensive record going back to 1995. That the offense was committed under circumstances unlikely to reoccur. That does not apply. Mr. Parton frequently abuses alcohol, is frequently violent as a result of his alcohol use. Therefore, he's frequently interacting with police officers. And that the offender shows genuine remorse. Again, Your Honor, there was a mountain of evidence against Mr. Parton. There was video footage of the attack. He admitted that he did it and his purpose for doing it. Officer Travis suffered serious physical harm that was documented in medical records that were provided to Mr. Parton and his attorney prior to trial, and he still refused to accept any responsibility for what he did on that day. And even in the pre-sentence investigation, he never provided a statement. So even to this day, he has failed to show any shred of remorse for what he did to Officer Travis. So considering the overarching principles of sentencing in the state of Ohio, there's a strong need to incapacitate Mr. Parton, to prevent him from hurting anybody else, to prevent him from committing any other crimes, to force him once and for all to seek some type of recovery by having a long, extended amount of time in prison where he doesn't have access to alcohol. And we owe it to the community. Officer Travis is a dedicated public servant who not only served as an officer on 2 separate police forces, but also in his day job is an assistant principal. This man dedicates his life to serving the public. This is exactly the type of person that we want as a police officer in our community. And now we don't have that anymore. And he doesn't have that anymore. Everyone is worse off because of what Keith Parton did. The only appropriate sentence for Mr. Parton would be a term of incarceration from 10 to 15 years. Anything else would demean the seriousness of the offense. Thank you.
Thank you, Prosecutor Roman. Mr. Perry?
Thank you, Judge. Okay if I stand here?
Yes, as long as Mr. Parton can hear, yes.
Mr. Parton, can you see me okay here? Okay. So Judge, first of all, I want to thank you and thank, the opportunity to be able to come in front of you today and speak on Mr. Parton's behalf. We don't take these matters lightly. We got the PSI, was able to review it, was able to see my client's history, and to see, exactly what was occurring in this case in his mind before or on this date of the offense. What I'll tell you first is that nothing I can say today can, relieve Officer Travis's pain, what he's been through, and what happened in this case. But I will remind you that Mr. Parton did indeed admit he did this on the day of the incident. What he conceded, though, was that it wasn't as serious as what it seemed to be. He admitted he assaulted the officer.
Wait, hold on 1 second. Mr. Parton? Can you unmute him? Here. I can't. Are you unmuting him?
Yeah. There you go.
All right. Mr. Parton, you're gesturing. Is there something that you want to say?
I didn't take the PSI, I turned the PSI down, it's on
Okay.
your record.
As I said, you will have an opportunity to be heard. I just want to make sure you can hear everything that's going on right now. Mr. Perry is making an argument on your behalf, and then you will have a chance to address the court and anyone in the courtroom. Understood?
Yes, ma'am.
Okay, thank you. Continue.
And I want to let the court know again, Your Honor, that he's not trying to belittle what happened to the officer. He's not trying to say, it wasn't, it's not what it is, but he's saying it wasn't as serious as it is made out to be. And so that on his behalf shows some kind of conception of knowing what happened here, knowing what his actions, perhaps led to, and just saying, hey, I should be punished for what I did, but not anything more than that. What I'll also remind the court is that Mr. Parton does have significant mental health issues. And I know this court is well versed in handling mental health. You run the Awesome Hope Court here at the Summit County Courthouse, and you're aware that mental health is a real issue in our society. Not to take away from what happened here, Judge, at all. Nothing I can say can take away from that. But just to remind the court, we did have him, screened for mental health issues. There are clearly some issues there that he perhaps was not being treated for. And I'll just say frankly that the alcohol use exacerbated what he already was going through. And that he voluntarily, obviously, chose to self-medicate with the alcohol. But I know this court has a duty to do today, to look at the things, look at the case on both sides, to not only correct Mr. Parton's behavior, but to also try to rehabilitate him. And that's what I'm asking the court to do, Judge. Simply sending him to prison for 10 to 15 years is simply punishing the act, not trying to correct the behavior. Not rehabilitating this young man when he comes out at some point, years down the road from our ODRC. I would ask the court to at least give this man a chance to come back and get rehabilitated. Treat the issues, treat the mental health concerns that we have for him. Allow him to correct his behavior. Reading the PSI, I did see several crimes that were committed back in the 90s and early 2000s. And I believe the most recent crime of felony violence was back in 2007. He did serve a period of 3 years in prison for that case. He got out and he did reentry court. And I don't know which judge that was with, but at least it shows some ability on his behalf to comply with orders and rules and to abide by regulations through our reentry court here at this courthouse. Since then, there was one other case in 2011, a felony aggravated assault that was found not guilty, so that's not obviously a conviction on his record. But no other crime of violence, felony crime of violence since 2007, some 16 years ago. I do know these officers have seen him many times in Norton. That's where he resides with his father. And even from the beginning of this case, I got a call from his dad who was very concerned about what his son was involved with, telling me that his son needed help, had mental health, issues and things he was trying to take care of, and he didn't properly take care of those things. So I'm just asking the court to look at what happened here, not only in the form of let's punish the act, but what does this man need when he reintegrates into our society to become a better person? What can help him on the other side, get a job, perhaps make a livable wage, perhaps find a place to live, perhaps not have any more contact with any of these officers that are here today, or any other officer for that matter, Judge. So we'd ask you to go somewhere lower than that 10 to 15 years, not asking for the minimum term, which is 2 years, but somewhere in the middle of that, I think is, considerably fairer for what Mr. Parton did here. I'd ask you to at least, again, hear from him and what he has to say today.
Thank you, Mr. Perry. Okay, Mr. Parton, at this time you may make a statement. Is there anything you would like to say before I impose your sentence?
Yes, I'm on medical disability. I don't need a job. I don't remember getting the proper medication from workman's comp when I was hurt on the job. And I didn't get any medications. And I couldn't go in there and tell them I needed medication, so they just got rid of me saying I was searching for drugs. So I had no choice but to take the medication that the doctors gave me and deal with the rest of the pain with the alcohol. And everybody was trying to set me up for OBIs and DUIs.
Anything else you want to say?
I don't know. I don't believe anything that man said. And did you check all the information that he gave the court with an investigator to see if that's proper information that he's handed the court?
All right, thank you, Mr. Parton. All right, first and foremost, I have had a chance to review the pre-sentence investigation, and I'm certain that the parties have also done the same. I just want to ensure that that did occur. Yes?
Correct, we did.
Mr. Roman?
The state had the opportunity to review the PSI.
All right. In addition, I reviewed the sentencing memorandum provided by Prosecutor Roman, and obviously I was present for the trial and also present for Mr. Officer Travis's statement today. Mr. Parton, I will remind you that you have certain appellate rights. They are limited, but if you wish to file an appeal, you have to do that within 30 days of today, your sentencing date. If you cannot afford an attorney, one can be appointed to represent you for the appeal. In addition, once you are released from your prison sentence, you will be placed on a period of post-release control, which will be mandatory for any time between 2 and 5 years. That is supervision by the adult parole authority, that if you violate it, you can be sentenced back to prison. If you are convicted of a new felony while under that supervision, you could be sentenced on the felony and face additional consecutive time up to 1 year or whatever time remains on that post-release control, whichever is greater as a maximum. Do you understand that, Mr. Parton?
Yes, I understand what you said.
Thank you. As I discussed with you at the time, actually perhaps I didn't, you will be subject to an indefinite sentence on this matter because of the nature of the charge, the level of the offense, and the time at which it occurred. That means that a minimum sentence will be determined by the court. 1/2 of that will be added to determine the maximum sentence. There is a presumption you would be released at the end of any minimum sentence. However, that that presumption can be overcome, but not without a hearing at which you would have an opportunity to be heard. In addition, there is a presumption that you would earn good time while you are serving that sentence. That presumption, again, can be overcome, but not without a hearing, and you would have a chance to be heard. Do you understand all of the effects of an indefinite sentence?
Yeah.
I'm sorry? Okay, thank you. All right. Based on the facts and circumstances and consideration of all relevant sentencing factors, applying the minimum sanction the court has determined will protect the public and also punish the offender without imposing any unnecessary burden on state or local resources, a mandatory prison sentence is appropriate in this matter, and to not sentence you to the Ohio Department of Corrections would demean the seriousness of the offense. Mr. Parton, you have had ample opportunity to show some remorse with regard to this case. And to this day, and up until 4 seconds ago, you have never once apologized or shown any remorse with regard to this act that was senseless and unprovoked. To walk up to a police officer who is sitting in his vehicle, minding his own business, and sucker punch him is just unbelievable. There truly was no reason to do that. And you have not shown any sense of responsibility for the act. And while I will agree on one thing, it is that I don't think anybody could have foreseen the amount of damage that it has caused Officer Travis. I don't think anybody knew that a punch to the face was going to result in such serious physical harm that impacted his mental ability, his ability to serve, his ability to continue in his employment, his ability to be financially stable, interact with his family. Mr. Parton, you had a chance. Mr. Parton, you had an opportunity to be heard.
Damn, he's making money.
You had an opportunity to be heard. And you continue to make excuses.
I ain't got no excuse.
And divert from this act.
He's making money.
I'm sentencing you to a period in the Ohio Department of Corrections of from 9 to 13 and a half years. This is a mandatory sentence. You will serve all of that and are not eligible. Okay, if you're going to continue to interrupt me, I'm going to have to mute you, Mr. Parton. You've had your chance. That is, as I said, a mandatory prison sentence. You are not to use drugs, alcohol, or any illicit substances while you are incarcerated, and you will be tested for certain substances while you are incarcerated. In addition, there is jail time credit. That number will be reflected in your journal entry. I will hear from the state if there's anything that I have forgotten.
I don't believe so, Your Honor.
Mr. Perry?
Nothing of which I'm aware. Thank you.
All right. Thank you. Mr. Parton, you are now able to go back to your pod. I wish you luck. I hope that you come to realize your part in this and take responsibility at some time and find some closure. Thank you. Thank you, folks.
Thank you.
Thank you, Your Honor.
Thank you, everybody.
Dan DeRose with 19 News. You've been watching the sentencing of Keith Parton for his attack on an officer, as we heard, was just sitting in his police cruiser, as was pointed out, was doing the right thing, was on a phone call with, and you can see the officer there, he was on a phone call with his brother. It pointed out in court he did the right thing by pulling over to talk to his brother on the cell phone so as not to be breaking law. Driving and talking on the cell phone, and that's when he was sucker punched. Really no issue, hadn't been talking to Keith Parton. This wasn't a traffic stop. It was a blatant, as the judge put it, a sucker punch. You could hear Mr. Parton was not happy, interrupting the judge several times, and the judge had to say he had been given his chance to speak. And then even with the interruptions, handing down a 9 to 13 and a half year sentence. Justice for that man right there, who, as we heard, an officer in multiple communities, as well as an assistant principal. The state pointing out this is a man who has dedicated his life to serving, whether it's as an officer or in the realm of education, and did not deserve all of the issues he currently has. Headaches, fear, can't remember certain things, doesn't want to put other officers' lives at risk by returning to work, and is going to be dealing with this act for some time. 9 to 13 and a half years is the sentence for Mr. Parton. If we have any other breaking news, we'll bring it right here to you on our digital platforms. Otherwise, watch for our 11 o'clock and our noon news on CW43 and on Channel 19. Until then, I'm Dan DeRose with 19 News Now. Have a good afternoon.
19 News is everywhere.